Okay, good morning everybody. Very happy to see you so many on Saturday morning. I'd like to say that we are very proud and very honored to have Koen Lenaerts for giving this distinguished lecture of the Academy this year. I'll be short in my presentation of Professor Lenaerts, since I think it doesn't need to be introduced to European lawyers. He is well known, recognized as playing a major role in the evolution and development of European law in the past 20 years. As an actor, as a lawmaker, Koen Lenaerts has been working on the Court of Justice of the European Union since 1989, I think. First as judge at the Court of First Instance and then judge at the Court of Justice, recently appointed Vice President of the Court. But he is also one of the most important scholars in the field of European law. He is a recipient of many academic prizes and distinctions. He has written widely on questions of European constitutional law, procedural law, fundamental rights, European citizenship, internal market law, European policies, external relations, the European judicial system, to give but a few examples of his areas of competence. The Roman and Latin poet Terence once said, "I am a human being, and nothing that is human is alien to me. Nothing that is human is irrelevant to me. Homo sum humani nihil a me alienum puto." The same can be said of Koen Lenaerts. He is a European lawyer, and nothing that is related to European law and Europe is alien to him. But there is more than that. What is really appreciated and admirable in his work is not only a continuing enthusiasm about the European project, but also his lucidity and his ability to structure the experience of the European Union, which is a living experience in his case, to give a sense and to restore the unity of this highly unstable, fragmented, and uncertain project. So thank you very much, Koen, for being here today, and the floor is yours.
Thank you, Loïc, for this very kind introduction. It is with great pleasure that for the third time, and each time in this Sala Europa, I'm taking part in the Summer Academy of European Law of the European University Institute. The first time was when many of you, when I see the audience here, were still probably in primary school. That was in 1990, in the very first session of the Summer Academy. Then as a young judge of what was then called the Court of First Instance, now General Court, still a first instance court to the Court of Justice. The second time was for a specialized course on comitology and institutional balance in 2000. And now is the third time that I'm here, always with the same pleasure. And this time, to deliver the distinguished lecture. What I shall do, by way of filling that in, is to share with you reflections on theories and methods of adjudication by the European Court of Justice. Methods of interpretation also. Because, as we all know, the Court of Justice, under Article 19 of the Treaty on European Union, shall ensure that in the interpretation and application of the treaties, the law is observed. That is a very general mission statement. And listen carefully. In the interpretation and application of the treaties, that is, in the process of doing that, the law is observed. What few people notice on a daily basis, even when working on a daily basis in European Union law, is that the treaty contains, right from the beginning, because this Article 19 is only the renumbering of a provision which has been there since the 1950s. Reference is made to a concept of the law which transcends the treaties, because it is in the interpretation and application of the treaties, that is the primary law of the Union, that the law must be observed. So it's something which goes beyond. So my purpose today is to see how the court handles that mission statement. Because, as we all know, it is often said that the Court of Justice somehow is an over-activist court, going well beyond the bounds of written law, and in doing so confuses the political with the judicial role. My argument today is to say that the court is really a judicial body, a judicial institution, working in accordance with the methods of legal construction, of legal interpretation, which are absolutely common to any court, be it national or international. But of course, in doing so, the court, yes, has to fill in blanks which are not readily filled in by the text of the norm to be interpreted. And that is why, when people speak about the court fulfilling a political role, what they actually mean is that the decisions of the court have an impact on the political process. That's absolutely certain. You won't hear me say the contrary. It has also an impact on the economic process. It has a cultural, moral, social impact in many ways. But that is to be distinguished from the question whether the court, in arriving at its decisions, acts as a political actor or remains faithful to its mission statement, that is, to see to it that the law is observed in the interpretation and application of the treaties. Now, what I'm going to offer you within the hour or so I shall speak, and thereafter we're going to engage in a question and answer session, is to give you a rough overview of the methods of interpretation. How does the court, practically speaking, handle issues of law which are not fully predetermined by the text to be interpreted and applied in the interpretation and application of the treaties? And that is, of course, interpretation and application of the treaties plus the law made pursuant to the treaties. That is then the secondary union law. So for all the uncertainties as to the proper scope of these norms, how does the court proceed, and does it, in so doing, act as a judicial actor, or should we criticize it for doing either too much or too little? Now you start reading, as you know, scholarly writing saying that the court is no longer activist, but minimalist. In the December 2012 issue of Common Market Law Review, there is an article whose main argument is that the court is no longer deciding more than a case at a time, which stands for the image of judicial activism, but is deciding maybe less than half a case at a time, which stands for, equally criticizable from the viewpoint of that author, judicial minimalism. So what is the truth of the matter? Maybe we'll have an answer at the end of this morning. Maybe. Or at least you will have more ideas, I hope, to formulate your own answers, plural, because I would doubt that we will all think the same at the end of this morning session. Methods of interpretation. I structure the talk in 3 parts. I shall first dwell upon the classical methods of interpretation under the subtitles textual interpretation, contextual interpretation, and teleological interpretation. And we'll do that in a very practical way, giving you examples. That's my first part. The second part is looking to the broader environment in which the code is fulfilling its role. The code is not operating in a vacuum. The European Union can be situated both vis-à-vis public international law in general, because the European Union, as a legal person of international law, is also somehow subject to international law, like any state would be. Does that influence the interpretation given by the code to norms of union law? Is that part of upholding the law? See to it that the law is observed in the interpretation and application of the treaties on which a union is founded. And equally, and that's a more obvious perception for all of us, the Court of Justice should be seen in relation to the national constitutional orders. That's the more classical vertical dimension, union member states. And my third and last move will be very shortly devoted to the interpretation of the Charter of Fundamental Rights of the European Union, which is subject to specific rules of interpretation and construction. Very sensitive area, as you know, also from the viewpoint of the federal balance between the European Union and the member states. So first of all, the classical methods of interpretation. Textual interpretation. It is often said that when I don't know whether I have somewhat more light here, maybe not. It's aha, that's the Lux Fiat, you see, that's already, thank you very much. That works. Textual interpretation is well known as a method of interpretation. It almost touches on the obvious. You say you'd simply take the usual meaning of the words. You start from what's there. And since a judge is not a legislator, in line with the trias politica thinking, the judge should be the mouthpiece of the law. Le juge comme la bouche de la loi. Génie. So that's the first start. And then the idea that interpretatio cessat in claris. When the text, for the Germans, der Wortlaut, beautiful word in German, der Wortlaut, well, how the text sounds almost. When the Wortlaut is clear, you don't need to go any further and just stick to that. That is serving legal certainty. It helps the subjects of the law to know what a court might say when the text is the object of litigation. Yes, but textual interpretation is very attractive as an abstract proposition. When you hear me tell this, you might say, if it's so easy, why go any further? That's precisely textual interpretation. But the reality is, as you may well be aware, that it is not always that easy. And this for several reasons, which have been well summarized in the famous Sylphid case, which you all know. It's a case of 31 years old, October 1982, in which a Court of Justice clarified the circumstances in which a Supreme Court of a member state may be relieved of its obligation to refer for a preliminary ruling. And the court explains that a Supreme Court, it's a court sitting without there being any further remedy against its decisions, last instance court, it will be liberated from its obligation to refer for a preliminary ruling whenever the answer is absolutely clear, acte clair. You know this. But then the court goes on saying, but watch out, Supreme Courts of the member states. Don't conclude too quickly that the text is clear and that you don't need any interpretation on the basis of the maxim interpretatio cessat in claris. Because, beware, there are, less at a time, but there are 24 authentic languages in which a text exists. What is clear in one language version may not at all be that clear in other language versions, and they are equally authentic. So there is no possibility of favoring just your language version. So it's not because you're sitting as a Spanish court that you can say, for me, the Spanish version is clear, and therefore the story ends there. No. I mean, you have to make the linguistically comparative analysis, which for a national court, with the human resources it has at its disposal, is almost impossible to carry out with full legal certainty. That is to make certain that the same clarity exists in all the language versions. Next, the court identifies the difficulties that concepts used in EU texts, although similar to concepts used in national law, may have a very different meaning. I give you one example of that, which I've myself experienced the first year I had made my transition from the General Court to the Court of Justice, now almost 10 years ago. And this was a simple value-added tax case in which we had to interpret the notion of immovable property, because some transactions relating to immovable property are exempt from VAT. And the question arose, what is immovable property? We say, well, immovable property, it's land and buildings on the land. That cannot be that difficult. Well, no, it is difficult. Because in a number of civil law systems, you have goods which are physically movable, but which are linked by destination to the buildings, which is typically the case for a factory, but can also be the case for an office building. Think about the services economy. So these goods, they are really affected. Their sole economic destination is to be used in such a context. So although they can be physically moved, they are still immovable. That concept is known in French law, in Belgian law, but not at all in the common law, for instance. So if you act as a continental lawyer, you may say it's very clear. But the same concept has a totally different meaning in another member state. And then there are situations where, although the text is clear, and that becomes already slightly more tricky, the context is somewhat hazy. And of course, you can't look to the specific provision, sentence or part of a sentence, without placing it back in the whole of the normative context. And that also might make a doubt. So textual interpretation, although we have to stick to it for purposes of legal certainty whenever it can be done, and sometimes even general principles of law contribute to the need of staying as close as possible to a text. Think of the law relating to criminal or other types of sanctions, where we have the well-known adagium nullum crimem nulla poena sine lege. That is, you can't get sanctioned for a behavior which is not clearly subject to a sanction the moment you committed it. That means that predictability is to the essence of that rule. Textualism is then a a welcome method of interpretation to make sure that legal certainty is respected. Textualism remains the starting point, don't worry, of every interpretation by the Court of Justice. But only the starting point. The Court of Justice will take multilingualism into account and the equality of all the language versions. You know from a case like Scoma Lux that the court takes this very seriously. An act of the union institution will only be opposable in the several member states when the act has been published in the official journal in the language of that member state. So the equality of the languages for acts with a general scope of application is a constitutional principle. And hence, textual interpretation is always subject to the full respect of that multilingualism. That for textual interpretation. As I said, I hinted to it already. Sometimes the text looked at it with the zoom lens on the specific wording of one article or one paragraph or one sentence even in a regulation, a directive, a chapter of the treaty may sound rather evident, even when comparing the language versions. Yes, but the text should always be looked at in the context. Why? If you take a specific wording which seems absolutely unambiguous, but you place it in the broader reading of the text as a whole, it may well have a content where you have the almost certainty that something else or slightly nuanced was meant than a first impression might have suggested. The context is relevant whenever the wording leaves a certain margin of appraisal. Now, what is the content? The context. The context has, in fact, two rather different aspects to it when you speak about the context of an act. First of all, you have to look at the normative instrument in which the provision you are going to interpret is occurring. So you don't take Article 3, Paragraph 3, Subparagraph 4, second sentence, just that sentence, but you replace it in the whole of the regulation. You read everything to see whether that sentence is not being influenced by the rest of the instrument. And you do that always. Even if the sentence all by itself seems to suggest a particular meaning, just to be sure. Why? The code starts from the premise, precisely because of trias politica concerns, respect for the legislator, that the legislator is a rational actor. The legislator will, when making the texts, see to it that each provision has added value to the text as a whole. So if a given interpretation of a text, although the text seems to suggest that interpretation, in fact means that the text becomes redundant because the same content is already flowing from another provision of the same normative instrument, then it indicates that probably you're wrong. Simply proceeding on what the text seems to contain. Why? A rational legislator will never include a provision which is the carbon copy, content-wise, of something else in the same instrument. So you should see to it that every provision adds something to the legal instrument as a whole, even though this might have as a consequence that you are interpreting the provision in question in a way which deviates from what you would have done if you had looked at that sentence all by itself. I'll give you immediately an example and then you will see what I mean. The second understanding of contextual interpretation is the whole issue of travaux préparatoires. I come to this. High time to give you now a few examples to illustrate this in a practical manner. And all these cases are recent cases, so that helps you maybe to, because there are already older theories about interpretation, but I try to confront them with the most recent case law, so to see for you how valid these different propositions are is easier with recent case law. The first example I'm giving you is the El Ghafaji case. El Ghafaji is a case of 2009, so that's still relatively recent. And El Ghafaji is a reference for a preliminary ruling from the Dutch Raad van State, Council of State. And it sought guidance from the Court of Justice on the content of subsidiary protection provided for in Article 15C of the Qualification Directive. The Qualification Directive is a directive of 2004 which contains the several conditions to qualify substance-wise either for refugee status, asylum seekers, under the Geneva Convention on Refugees, which has been referred to in that directive. And if you don't qualify as a refugee, but still you can't return to your country of origin, then you may apply for subsidiary protection. So here it was quite clear that El Ghafaji, that is Mr. and Mrs. El Ghafaji, two Iraqi nationals, they did not claim even to qualify for refugee status within the Geneva Convention, meaning this is a convention of 1951, and thus not under the Qualifications Directive rubric refugee, so that was not the issue. But they said, although we cannot claim personal persecution, because that's the criterion to get refugee status, we can't claim personal persecution, still the situation in Iraq in 2006 with indiscriminate violence, it is so dangerous that if we go back, we might well be killed. And therefore we ask for subsidiary protection. Subsidiary protection is sort of a widening of the category of protection for those not qualifying in the technical sense as refugees, yet given the context in bad need for protection. Now, this subsidiary protection is to be granted under the directive, that is, member states are obliged to grant such subsidiary protection in 3 cases, all three of which are included in Article 15 of the Qualification Directive. It says serious harm, that is serious harm which threatens to accrue to the person if sent back, serious harm may consist of A, death penalty or execution, so the risk of death penalty or execution. B, torture or inhuman or degrading treatment or punishment of an applicant in the country of origin. Or C, serious and individual threat to a civilian's life or person by reason of indiscriminate violence in situations of international or internal armed conflict. So you have A, B and C. The Dutch Raad van State, the referring court, asked us an interpretation on C, only on C. So El Ghafaji and his wife did not claim that they might be subject to death penalty or execution, nor torture or inhuman or degrading treatment or punishment in the country of origin. That was not their situation. But they referred to C. What is serious and individual threat to a civilian's life or person by reason of indiscriminate violence? Now, indiscriminate violence as a consequence of international or internal armed conflict. Frankly speaking, textual interpretation, our starting point, that is sort of bizarre, because there is an apparent contradiction. You say serious and individual threat to a civilian's life or person by reason of indiscriminate violence. Yeah, but individual and indiscriminate. There is a clear tension in situation of international and internal armed conflict. Now, looking quickly to the facts, Mr. and Mrs. El-Ghafaji had fled from Iraq, as I told you, and they argued the risk of serious harm if they were sent back to Iraq. Because they explained, before moving to Europe, Mr. El-Ghafaji had worked for a British company, providing security clearance between Baghdad airport and the Green Zone. The uncle of Mr. El-Ghafaji had been killed by a terrorist attack, and a threatening letter stating death to collaborators had been fixed on his door. He had worked for the British during the Iraq War. But the Dutch Minister of Immigration considered, nevertheless, that Mr. and Mrs. El-Ghafaji failed to demonstrate serious and individual threat to their lives. The minister said that the degree of individualization of the threat required by Article 15C was identical to the individualization of the threat required under A, death penalty, or B, risk of torture and degrading punishment. He said it speaks about individual threat as a consequence of indiscriminate violence, that's for sure, but it's individual. So all three letters require this individualization, and therefore, since you can't sufficiently demonstrate that you might be the target, you don't get your residence permit. He attacks this before the administrative court, which in the Netherlands is the Raad van State, and they refer the question of interpretation. Here you see, in a marvelous way, how the court goes about it. This is a sensitive political area. It involves no more, no less, and we all know this in Europe, certainly in the Netherlands, if you follow the political debate of the last years, this is immigration policy. And the local population is oftentimes very, very opposed to immigrants of all sorts seeking their fortune in the local country. So the minister, by saying no, is certainly acting in tune with what most of public opinion is always divided, is expecting from him or her to do. But of course the concerned person goes to court, and judges are there to uphold rights and to see whether there is a right in favor of the person concerned. So the Dutch Raad van State, as a very independent court, and much to its credit, says, yes, there might here be a problem. So refers the question to us. What does the Court of Justice say? It says the text here is clearly not sufficient, because it even contains an apparent contradiction, in a way. Individual threat, indiscriminate violence, as a consequence of an internal armed conflict, quod est. That's the case in Iraq. So what to do? So the court says, well, actually, Article 15A, death penalty, that corresponds to a protocol added to the European Convention on Human Rights, prohibition of the death penalty. B, that corresponds in essence prohibition of torture or inhuman or degrading punishment That corresponds to Article 3 of the ECHR. The letter C does not correspond to anything in the ECHR. It's something which the union legislator has added, something more protective. So you see, systematic interpretation in the context, the code says it must have an additional normative value. The legislator, remember, is a rational actor. If he has made the democratic choice to add a category, it must mean something. It means that he had the intention to be more protective than these two baseline protections offered by the European Convention on Human Rights. On that basis, the code says the individual threat can be much lower as a threshold than in letter A and letter B. The threat of death penalty is individual. The threat of punishment and degrading treatment is individual. But here, the individual threat can be meant as all individuals are being threatened, given the extremely high violence which is indiscriminate as a consequence of an armed conflict. So that's one. But second, the code said, of course, if there is nevertheless under letter C a possibility to show in actual fact that you are in this context of indiscriminate violence as a consequence of an armed conflict, on top of that individualized, like the story here shows, with the little sticker on his door, death to collaborators, that of course does individualize more, then the code says, a fortiori, such individualization on top of the indiscriminate violence makes the man qualify. And so, the Raad van State, after the judgment of the Court of Justice, of course, ruled in favor of the El Ghafaji couple. But it shows you, I hope, very clearly how the systematic interpretation combines with a textual interpretation. And although we all are for the legal certainty and the fact that a judge should not be too creative in order not to overstep the boundaries between what the legislator does and what the court does, such an example shows you that a national court, I come back to this a bit later, but notice it already now, a national court opens the gateway to the Court of Justice. Court of Justice never sets its own agenda, don't forget this. The court has pronounced on this extremely sensitive El Ghafaji case, which has a lot of resonance in the Netherlands thereafter, because it was the highest Dutch court in administrative law matters, the Raad van State, which opened the gate to the court and asked the court to rule on the matter. But it's the credit of the Raad van State, of the Dutch court, to have identified the problem, to have submitted it to the Court of Justice, and to have asked the Court of Justice to rule. That then the court does, taking into account the text and the context in which the text is occurring. Now, El Ghafaji is a strong example. There are more examples. And in a way, all these methods of interpretation are always a little bit intertwined. I, of course, separate them for didactical purposes of this lecture, but in actual practice, they come together. And I'll take a second and last example, because we must be limited on this part of the talk. That is the famous regulation of 2004, protecting the rights of air passengers as consumers. Maybe several of you have already made some experience with that regulation. It's a protection of the passengers who are stranded in an airport when their flight is cancelled. As you probably know, at least some of our children have already made a personal experience. When the flight is cancelled, and you are being rerouted by the air carrier, but in a way that you arrive more than 2 hours after your initially planned arrival time, or you have to be at the airport 1 hour before the scheduled time, so it's really the inconvenience of the time which is being calculated 1 hour in advance, 2 hours beyond. You'll see why it's important. So if you go out of that plage de temps, out of that time lag, you get a lump sum payment, compensation payment, on top of also practical help. You may have an hotel night and a meal and that sort of thing, but also you get a lump sum to compensate for the harm suffered on a forfait basis of the loss of time. And the amount depends on the length of the delay. Now, in the regulation, textually speaking, nothing similar is provided when a flight is delayed, but delayed drastically. The flight is sometimes delayed for 27 hours. That from the viewpoint of the passenger, you can perfectly ask yourself, is this still a delay, or is this to be seen as another flight? What is cancellation? What is delay? Because of course the air carriers, being creative business people, and at their place you can't blame them for it, they have of course been rebaptizing cancellations as long delays. So cases started coming from national courts where passengers who had been delayed for a long time, many hours, were claiming the same compensation as in case of cancellation. The air carrier is saying, this is not cancellation, therefore no compensation. So the national courts asked the Court of Justice, can delays be so important that in fact they should be assimilated to a cancellation? Now that has been a very, very difficult question, because textual interpretation, you read this whole regulation, you find in some of the recitals some identification of important delays to cancellations as far as the consequence is concerned, but in all honesty, it's rather thin. And in the provisions of the regulation itself, the articles, let's say, there you don't find anything on it. But if you look at the preparatory works, this broader concept of contextual interpretation, you do indeed find references to equalization, and especially you find in all shades and forms, shades and shapes, I would say, the objective of the protection of the consumer being the air passenger stranded in an airport. So what the court said is, the contextual interpretation implies that you read every provision of the text in light of the overall objective of the text, as it is revealed by the preamble to the text, further supported by the travaux préparatoires of the text, the Commission proposal, the way it was handled in the European Parliament and the Council. This was the ordinary legislative procedure. And all of that together, combined with the principle of equal treatment, looked at from the perspective of the passenger, because it was the passenger intended to be protected, rational legislator and not the air carrier, all of that together made that a court, first in the Sturgeon case, subsequently in the Nelson and Tui travel case of the ground chamber of the court of October 2012, equated the situation of the delayed passenger to the situation of the passenger of a cancelled flight, thereby taking away the incentive of air carriers to play strategy as between cancellation or delay. And the court even said that this was necessary as an interpretation potius ut valeat, which means for the non-Latin speakers among you, an interpretation consistent with a higher rule of law, namely the equal treatment rule, because otherwise that rule would be infringed and the regulation might even be invalid for having unequally treated situations which, from the perspective of the objective of the regulation, are objectively similar. And in the Sturgeon case in particular, Advocate General Sharpston had proposed to the court to hold the regulation to be invalid. The court did not want to do that because rational legislator, the court said, no, the legislator has meant something. It's maybe not ideally expressed, but it is nevertheless sufficiently clear what the legislator intended to do. Travaux préparatoires are now increasingly important. For a very long time, and in older scholarly writings you still find reference to this, travaux préparatoires were not only absent in the court's jurisprudence, but they were also being distrusted. First of all, for the initial treaties, they were not available. And second, it was felt that it was very dangerous to sort of second-guess the intentions of the legislator, the idea being that the legislator speaks through the actual text of the norm and not through what might have been the content of debates in the European Parliament or elsewhere. I think it's safe to say that that attitude now has fundamentally changed. The court now very regularly uses the travaux préparatoires. Also because they are now better available, frankly speaking. Take the Lisbon Treaty. The Lisbon Treaty is being interpreted on the basis of the works of the European Convention. You know, the Convention for the Future of Europe. That convention, which initially led to the treaty establishing a constitution for Europe, which as such failed to be ratified, but as we all know, the Treaty of Lisbon is for 90% identical to what should have been the Constitution for Europe. And the Court of Justice has not the slightest hesitation to look in the preparatory works of the Convention for the Future of Europe in finding the right interpretation of provisions which are newly inserted in the Lisbon Treaty. And for sake of time, I'm not going into any detailed explanation in that, but you're all aware of the litigation now pending at appeals level before the Court of Justice in a case called Inuit Tapirit. That is the case where for the first time the court will have to decide whether the regulatory acts, which can be attacked by way of an action for annulment by natural or legal persons under the 4th paragraph of Article 263 of the TFEU, whether such regulatory acts include or don't include legislative acts. That is this crossing out of the individual concern requirement for private parties. So you know that for regulatory acts, when they are of direct concern and they don't call for further implementing measures, that leads to admissibility of the action for annulment brought by a private party against a regulatory act. Now, there are, of course, also legislative acts adopted since Lisbon by way of regulation, directive, or decision, legislative acts which are so complete, clear, precise, and unconditional, to paraphrase Van Genten laws, that they are applicable as such. Can a private party say, I go to the General Court with an action for annulment against a legislative act, because that legislative act does need the slightest implementing measure. It's directly affecting my legal position and also my commercial interests, most probably, like in the Inuit case. So I ask its annulment. I'm not individually concerned within the Plowman jurisprudence meaning, but, you know, it's of direct concern, doesn't need any implementing measures. A legislative act is regulatory in the general application sense, and therefore I'm going against it. As you know, the General Court has declared this action to be inadmissible, stating that regulatory acts are acts of general scope of application, but which are not legislative acts within the meaning of Article 289 of the TFEU. And their reasoning was to an important extent based on the travaux préparatoires, the context of the provision, as revealed by the Convention on the Future of Europe. Because, as you know, in the Constitution for Europe, a distinction was made between legislative acts in the form of laws and framework laws, and then the executive acts, non-legislative acts, whether delegated or implementing, what is today 290, 291 TFEU, and those would be regulations or decisions. Directives had no longer that status. And then, of course, when you said regulatory act in the Constitution for Europe, it was very clear that it was not legislative acts. But then, on a proposal from Angela Merkel on the German presidency, first half of 2007, the very smart political move was made. Let's keep, in fact, the content of the treaty, establishing a constitution for Europe, but stripping it from all its constitutional rhetoric and appearance, which looks too state-like. So constitution goes as a name, laws and framework laws go, because all of that is too much calling the image of a superstate into being. No one thought about the fourth paragraph of what was Article 365 of the Constitution for Europe and 263 of the TFEU. So that provision, technical provision, remained unchanged. So the General Court, followed by Advocate General Kokot, in her opinion, in the appeals case, which is still pending in the court, so I can't tell you what the court will decide, but you have the General Court first instance and the opinion of the Advocate General. Both of them rely on the preparatory works to the effect that it was not the intention to soften or to widen, if you want, the access to court in favor of private parties by way of an action for annulment against a legislative act. Other examples is in the ordinary legislative procedure, when the Commission makes a proposal and that proposal is being amended in the Parliament, or in the conciliation committee at the third stage of the ordinary legislative procedure between the Council and the Parliament. All these documents are publicly available. Of course, parties argue that the meaning of the end text should be seen against the backdrop of the development of the legislative proposal, initial legislative proposal, through the legislative process. The court will always take that into account. The same has always been done, by the way, for the private international law conventions, where the Court has always and extensively quoted the Génard report, the Schlosser report, so in all these private international law instruments, which precisely were published in order to reveal the context of the case. Now, the third and last classical interpretation is a teleological interpretation. In a way, I have already referred to it, because the telos of a text is the overall objective. Now here, a number of remarks. First of all, teleological interpretation has often been criticized for its potential of judicial activism, its potential of competence creep operated by the Court of Justice in favor of the European Union and at the expense of the member states, etc. The truth of the matter is that the European Union as a whole is a functional entity. The European Union is not a goal in itself. The European Union is first and foremost a means to reach some goals. And it's not me saying this. If you open the TEU, the TFEU, the first thing you read is objectives. Why are we doing this? Why are we bringing these most diverse 28 member states together in a single union? Not to make, like in the United States, one nation indivisible under God. Surely not. But we're doing it, to paraphrase Mireille Delmas-Marty, in order to order pluralism. The European Union is essentially an exercise of ordering pluralism, of coherently and consistently bringing together member states' legal traditions, interests, values, through the exercise of shared competences. Competences which are only conferred on the Union in order to reach some objectives. And if you tonight do the exercise and you close your eyes, you take the treaty, you open it randomly, at whatever page, I bet you will find on that page objectives. Because not only are there objectives in the beginning of the treaties, but each competence title, whether it be environment, internal market, industry, cooperation with developing countries, anything, any competence conferring title, economic and monetary union, it starts with objectives. So when the Court of Justice is engaging in a teleological interpretation, it is in large extent at the same time engaging in a textual interpretation, because the text is worded in the form of objectives and means, but also objectives, first and foremost. And the objectives constitute at the same time the context in which each particular provision is to be placed. That is why teleological interpretation is not an expression of judicial activism. Teleological interpretation is to a large extent textual interpretation. Even in Van Gent and Loos, whose 50th anniversary is being celebrated in a number of conferences, including one at the Court of Justice this very year. If you look at Van Gent and Loos and the way the court proceeded, that is totally in conformity with what is today Article 31 of the Vienna Convention of the Law of Treaties. The usual wording of the text, the context, and the object, the objective. Text, context, telos, teleological. But the court says, and that's in my view the strongest argument in Van Gent and Loos for direct effect, the court says, here are these national courts which have the power to bring references for preliminary rulings. They're directly being empowered by what is today Article 267 TFEU to bring references for preliminary rulings on the interpretation of all the rules of union law and on the control of the validity of acts of the union institutions. Such a mechanism doesn't make any sense. It's almost bumping into an open door. If national courts cannot somehow be confronted with these rules, right? That means that parties litigating in front of these national courts must be able to invoke these rules of union law. Otherwise, a question on their interpretation or on their validity simply cannot arise. So it is the text of 267, then 177 in the EEC treaty initially. It's the context of the treaty as a whole. What our good friend, Advocate General Poyares Maduro calls is almost a meta-teleological, a meta-telos, sort of the general system of the treaty, which is being revealed through discrete expressions in the text. The text seen in the context, in the light of the preamble, in the light of preparatory works, revealing a telos, revealing a system, the general economy of a system, the system of the treaty. That is really what a court does in terms of saying what the law is in the interpretation and application of the treaty. Now, what is often also misunderstood is that a teleological interpretation is not always an extensive interpretation. My experience is even, and it may surprise you, that a teleological interpretation is in just as many cases a reduction of what the text might suggest. And I give you first a general example and then one out from the case law. A text written in its sort of brutal wording might be over-inclusive or under-inclusive. My example of Sturgeon and Nelson and TUI travel, these two examples about the air passengers' rights, that's in my view an example of an under-inclusive text. A text which meant to protect all stranded passengers who have to stay over for more than 5 hours, let's say. By the way, now the legislative process is amending the regulation in line with our case law. Just that's a beautiful example of the interaction between the judicial and the legislative process. But it was clearly an under-inclusive text. That's true. So we said, no, you can't discriminate between the two, the general principles, the objective of the regulation, and we proceeded from that. The text was under-inclusive. The teleological interpretation broadened it. But the reverse happens much more often. If you take a random competence of the Union on education, if you take the table of contents of the treaty, TFEU, you find the title Education. Then you say, gee, education. I thought that should be national and maybe in a country like Belgium, regional, because also in Germany, Bundesländer Kompetenz, Kernbereich, der Länderautonomie. So that's local. What should Europe do? Then you open the text of the article, Article 165, and the first thing you find is a very precise list of objectives that can be pursued by the European Union in the field of education. The objectives there serve as a reductionist device to say, no, don't proceed on a false impression. It's not just education being conferred as a competence to the Union. It is only with a view to A, B, and C, these objectives, that the following means may be used, and then a whole range of means which may not be used, although they might be useful to reach these objectives, etc. So then you come to a very subtle balance. So there, interpreting the objectives and knowing whether something falls within the objective or not serves rather as a limiting device than as an expansive device. Sometimes the court does even so expressly. And I give here as an example a case which is, because we have to take a bit every field of the law by way of example, it's a Brussels Convention case. But as you know, Brussels Convention, now it's Brussels I regulation. It's a case of Calfelis. I don't know whether you are a bit familiar with the private international law on conflict of jurisdictions. You see, EU law goes in every subject matter. So that's the question to know in civil and commercial matters, which member state court is competent, and if that court is competent, has jurisdiction within the meaning of this EU instrument on jurisdiction, recognition and enforcement of judgments in civil and commercial matters, the decision of the competent court will be recognized and enforced everywhere else in the other member states. So it is very important that these rules on jurisdiction be interpreted uniformly so as to have the avoidance of conflicts of jurisdictions, which is precisely the raison d'être of this private international law instrument of EU law.